Dr. Derek M. Powell is an associate professor in constitutional law and government at the University of the Western Cape in South Africa and is a non-resident fellow at the CGA. He's a former senior official in South Africa's post-apartheid government and historic constitution-making process. And he's also the author or editor of 3 books on constitutional law and government, whose legal education was in South Africa and the US. So without further ado, I'd like to turn this over to Dr. Powell for today's presentation.
Thank you for that kind introduction. The broad theme that I've chosen for this talk is the following. In a global health emergency, such as the COVID-19 pandemic, when governments resort to using emergency powers, what happens to the delicate balance between law and government that lies at the heart of constitutional democracy? This idea that constitutional democracy is founded upon a balance between government and law, I have borrowed from Sir John Laws's 2013 Hamlin Lectures and subsequent book entitled The Common Law Constitution. As a former government official and as a scholar of constitutional law, I'm interested in both sides of the government v. law equation, in how the right balance between them is won and held in different contexts, particularly in the exceptional circumstances of a global pandemic. It is a useful frame for what I want to talk about because the pandemic and the wide and intrusive emergency powers that governments have used in responding to the crisis has profoundly disturbed normal relationships between government, parliament, the judiciary, and fundamental rights. If normal life is fully to resume, once the pandemic is over, the nature and extent of what has happened must be understood, and the constitutional equilibrium between the arms of government and the normal protections for fundamental rights must be restored. The borrowing is also my way of paying homage to a great British Justice of the Appeal Court and legal scholar, Sir John Laws, himself one of the millions of people who tragically lost their lives to the disease. What effect the pandemic and the use of emergency powers have had on the institutions of constitutional democracy and the rule of law is something that each country will have to determine. The striking fact about this pandemic, however, is that in all constitutional democracies, simultaneously and over a protracted period of time, the foundations of constitutional government were tested in more or less the same way. That has never happened before, and it means that scholars and reformers thus have an enormous body of comparative experience to draw on in strengthening governance and legal frameworks in readiness for a future pandemic. It seems likely that reform of governance and law in some degree on the basis of this experience will occupy most countries for years to come. What I want to do today is merely broach the subject of what good constitutional government means in a pandemic. The subject is vast and too complex to do more than that in this short talk. Here I want to do 4 things. First, I want to raise 3 key questions that I think lie at the heart of the global project to rebalance government and constitutionalism in the aftermath of the pandemic, and to explain why these questions matter. Secondly, I want to contextualize these questions within the wider international legal regime that governs public health emergencies in the world and look at some of its key features. Thirdly, I want to examine the tension that exists between the use of emergency powers to protect public health and the protection of fundamental rights from government overreach, a tension that was obvious in many constitutional democracies. Finally, I will conclude with a brief reflection on some of the most important common issues in the restoration of this constitutional balance that have emerged in the international legal literature on the pandemic. Let us begin with the 3 specific questions that inform my own research into the resilience of constitutional government and the rule of law in the pandemic. Some of these questions are examined in a forthcoming volume to be published by Macmillan Palgrave this year, entitled Constitutional Resilience in the COVID-19 Pandemic, Perspectives from Sub-Saharan Africa, edited by my colleague, Professor Ebenezer Durajai, and myself. The first question is really about the legal basis and reasonableness of government responses to the public health emergency. The question is, were emergency public health measures legal, necessary, and proportionate responses to the crisis? Almost all countries had legal rules and standards to regulate the use of emergency powers. Whether those standards were adequate and whether government measures conform to them are obvious points of departure for inquiry and law reform. The second question is about the democratic and legal constraints that were imposed on government emergency powers, specifically by legislatures and courts. In most countries, executive power appeared to increase during the pandemic, and legislative and judicial oversight seemed to be attenuated. The normal balance of power between the three arms of government was disrupted. The question we need to ask is, what roles did legislatures and courts actually play to authorize, oversee, and constrain the actions of executive government? These two arms of government have important constitutional responsibilities to safeguard constitutional democracy, the rule of law, and human rights from government overreach and abuse. In an emergency, these roles must be performed without compromising the government's responsibility and right to take the emergency measures it thinks are necessary to protect lives and public health. What we want to know is, how did legislatures and courts strike that balance during the pandemic? The third question is about when and how fundamental rights of the individual can be limited in order to protect public health from a novel, highly transmissible, and deadly disease. Law permits government the use of powers, of emergency powers, when the life of the nation is endangered. Law allows certain rights to be limited, subject to internationally accepted standards of legality, necessity, and proportionality. The question is, when is the limitation of a fundamental right a necessary, rational, and proportionate measure to save lives and protect public health? And who decides that? I will focus on the first and third questions related to government and human rights in this talk. Say something about how courts have sought to strike that constitutional balance by offering a few examples, but leave the problems of parliaments aside for this talk. Now, why do these questions matter at all? In the first place, because government, parliament, the courts, and protections for human rights are the principal institutions of constitutional democracy. That is to say, these particular institutions define government that is based on consent and under the constraint of law. They distinguish constitutional democracy as a form of government from autocracy and rule that is mere force. The dividing line between the roles that each institution plays in a constitutional system is often easier to draw in theory than in practice, but it is regularly drawn in practice, often in the face of great perils, such as war and pandemics. These were also the institutions that were at the forefront of the global effort to manage the pandemic and to protect public health. Countries have their own variants of each. That is true, but most variants of constitutional democracy are variations on these ideal types in some form. We see the basic constitutional scheme for government based on consent and the rule of law in, for example, the United States of America and New Zealand, Kenya, Germany, and India, in both common law and civil law traditions, in systems based on constitutional and parliamentary sovereignty, and across all regions. It was these institutions that had the constitutional responsibility to contain and manage the pandemic in order to protect the health of the nation, while conforming to the national and international law that regulates the use of emergency powers in a public health crisis. All have been tested everywhere and as never before. Each country has generated a body of experience that illustrates what good constitutional governance looks like in a public health emergency such as this one, and what conduct does not pass constitutional muster. The second reason why these questions matter is that it is between these particular institutions that Sir John Laws's constitutional balance must be struck in normal times and during emergencies of this kind. If constitutional democracy is to survive shocks like this and help countries manage the ever-present conflicts in society, then equilibrium between these particular institutions must be continually struck and vigilantly maintained. In his 2013 Hamlin lectures, the late Sir John Laws argued that the unifying principle which binds these institutions into a viable constitutional order, is a hard one, hard to keep, delicate constitutional balance between law and government. The third reason I think these questions are important is that the constitutional balances we ordinarily associate with normal times were profoundly disrupted everywhere on a breathtaking scale. Governments ruled by decree, normal procedures of parliamentary and judicial oversight were suspended or attenuated for lengthy periods of time. Governments exercised extensive control over almost every facet of the daily life of entire populations. Severe restrictions were imposed on a wide spectrum of human rights and freedoms. Disequilibrium and possible conflict between government and law was also a constant refrain in the public health measures that were introduced, in the guidance of international health and human rights bodies, and in the jurisprudence, scholarship, and commentary that has emerged during the pandemic. The tension was often framed in binary terms, as a tension between necessity and the rule of law, or as between the responsibility of governments to act and the legal constraints that limit their action, or between the restriction of individual rights and freedoms to save lives and protect the public health, and the protection of valued rights and freedoms from abuse and government overreach. It should be understood that governments have the right and the duty to use emergency powers in a public health emergency such as this one. That principle and practice is well established under international and national law. Special legal regimes for emergency powers exist at both levels and apply in these circumstances. We will consider the legal framework for the pandemic in a moment. It is an equally well-established legal principle that emergency powers remain subject to the rule of law, notwithstanding the emergency. The ends do not justify the means, and governments do not have a legal license to unbind themselves from all legal constraints, not in a constitutional democracy. As Associate US Supreme Court Justice Stephen Breyer makes clear in his book, The Court and the World, American Law and the New Global Realities, published by Vintage Books in 2016, even in a national emergency, governments do not have, quote, a blank check, unquote, to rule as they see fit. On this point, Justice Breyer recalled James Madison's 1792 description of what a constitution is, namely, quote, a charter of power granted by liberty, and not a charter of liberty granted by power, unquote. Indeed, every emergency measure which a government employs in response to a public health emergency must conform to specific legal criteria to be valid. When the pandemic first occurred, there were clear and universally accepted legal standards for the limitation of rights in an emergency already in existence and in use. These standards understand an emergency measure to be a temporary measure based on law, necessary to achieve the objectives of protecting public health, a proportionate means to achieve that end, and non-discriminatory in its application. These are bedrock principles of the 1985 Syracuse Principles that seek to harmonize the limitation and derogation of human rights that are protected under the International Covenant on Civil and Political Rights and other universal and regional human rights treaties. They were also continually affirmed throughout the pandemic by all UN human rights treaty bodies and regional human rights treaty bodies, national courts, and by legal scholars. The Syracuse Principles are virtually identical to the proportionality tests for limiting fundamental rights that are ordinarily applied by many courts when balancing the state's actions against the rights limited by those actions. When a constitutional right is prima facie infringed, the onus is on the state to prove that the limitation is a legal, necessary, and proportionate restriction to achieve a legitimate objective and tailored to that purpose. Constitutional balancing is thus central to what courts do when they exercise their powers of judicial review to protect rights, without crossing the line into terrain that belongs to governments or legislature, by replacing legitimate political decisions by democratic authorities with their own. What the constitutional balance between law and government allows generally in a public health emergency is, to quote John Laws again, merely efficacy, but it forbids oppression to the power of the state. Each country must determine for itself how far the constitutional balance was disrupted in the pandemic and how it should be restored. But a reckoning is necessary, and one is likely, for reasons which John Sumption gave in a recent lecture at Cambridge University, to which I will refer again later on. He said with respect to the UK emergency measures that, quote, such a remarkable departure from our liberal traditions surely calls for some consideration of its legal and constitutional basis, end quote. I think there is another reason to take stock, which is that countries can learn from the experience. What constitutional balance between government, parliament, court, and rights is appropriate and effective in a public health emergency without fundamental values being sacrificed? Let us look briefly at the wider international legal context in which the pandemic played out and where these questions also resonate. There is, of course, no world government, no universal system of public law. What we have instead is a polycentric transnational system of health government that consists of three interacting fields of public law, each having international, regional, and national dimensions. Other fields of law are also important, but international health law, international human rights law, and national constitutional law are where the fundamental questions related to the legal obligations of states and the rights of individuals in a public health emergency arise. A coherent and effective international legal framework is necessary for international cooperation in a pandemic for at least three main reasons. In the first place, preventing and containing the spread of infectious disease is quintessentially a problem of collective action between states. Infectious diseases do not respect borders, and therefore what happens within the borders of one country matters everywhere else. International health law thus provides a framework to coordinate collective health responses among sovereign states that have a common stake in stopping the international spread of disease. Secondly, the legal framework is a determinant of health and human rights outcomes. Law defines the normative, legal, and practical responsibilities of states and the World Health Organization in a public health crisis. Law establishes the institutions, processes, and methods of the global governance system that come into operation in a pandemic. Law defines the rights and obligations of individuals and the terms on which they may be limited in a public health emergency. As well as a natural phenomenon, therefore, a public health emergency is also a legal phenomenon and a problem of governance. Thirdly, assessments of practice during the pandemic show many shortcomings in these legal frameworks. We won't have time to go into these assessments, but there are likely to be many in the years to come as we take stock of the efficacy of this framework. The key legal instrument for coordinating the public health response to the pandemic was the International Health Regulations of 2005. These are binding regulations in terms of the Constitution of the World Health Organization. Article 2 of the International Health Regulations defines the purpose of the regulatory system as being to prevent, protect against, control, and provide a public health response to the international spread of diseases to restrict the public health risk while avoiding unnecessary interference with international traffic and trade. There again, we see the balancing between protecting the interests of trade and protecting public health from a transmissible disease. The regulations set out the obligations of the World Health Organization and the international state parties in respect of notification, preparedness, and response to a public health risk. Two aspects of the regulations are of interest here. The first is the power of the Director General of the World Health Organization to declare under certain circumstances that an event is a public health emergency of international concern, and to make temporary recommendations to state parties on public health measures to be adopted. A public health emergency of international concern is an extraordinary event that is deemed to be a public health risk to other states through the international spread of disease, and that could warrant a coordinated response. A public health risk is defined as a serious and direct danger to human populations that may spread. A health measure is in turn defined as any procedure to prevent spread or containment, but it does not include law enforcement or security. In the case of COVID-19, that declaration was on the 30th of January 2020, and it triggered the international public health response. On the 11th of March 2020, it was declared a pandemic. Although World Health Organization recommendations and guidance were non-binding and varied in step with the pandemic, WHO guidance had a considerable influence on the type of national public health measures that were introduced and the manner in which they were implemented. To the extent practice in this pandemic can be a useful legal yardstick of the kind of public health measures that are consistent with the standards of necessity and proportionality, limitations of rights, the practice that has been developed under the guidance of the World Health Organization is instructive. International human rights law, on the other hand, is anchored on the two main universal covenants and many other universal and regional human rights instruments. International human rights law defines the obligations of state parties to respect, protect, promote, and fulfill fundamental human rights, and seeks to guarantee remedies for serious infringements. Human rights are interdependent, but different categories of rights have different consequences for state obligations. Some rights in the International Covenant on Civil and Political Rights can never be derogated, not even in an emergency. These include, for example, the right to life and freedom from torture. Other rights can be suspended in an emergency, provided that a state complies with notification and derogation procedures set out in the Convention. Some rights have inbuilt limitations for public health emergencies, for example, which include, among others, the right to freedom of movement, the right to manifest religion, freedom of expression, the right to peaceful assembly, and the right to freedom of association. Rights that can be derogated can also be limited in accordance with the Syracuse Principles. That then is the international regime for civil and political rights. But there are also social, economic, and cultural rights contained in the International Covenant on Economic, Social, and Cultural Rights. These rights are different in that they are to be progressively realized by states within their means. But states also have certain minimum core obligations arising from the covenant. Article 12.1, for example, recognizes the right of everyone to the enjoyment of the highest attainable standard of physical and mental health, a right that was at the center of this pandemic. Article 12.2 requires states to take necessary steps for the realization of this right, and that include preventing, treating, and controlling pandemics. Again, a responsibility that was at the center of the pandemic. In general, the extent to which international law is binding in national law in a particular country context will depend on many factors, including how international law is incorporated into national law and the type of right in question. The third domain is national constitutional and public law. It is here where the powers and obligations of governments in respect of emergencies, public health, and human rights are regulated and given practical effect. Most countries have provided for emergency powers in law, either in the constitution, in legislation, or in both. In response to the pandemic, government powers were drawn from many types of legislation and often multiple sources. The studies of emergency regulatory powers show that while most countries provide for states of emergency in their constitutions, many, if not most governments, have in fact relied on statutory powers under public health, disaster management, or special COVID-19 legislation. Now let us turn to the executive. From the outset, the role of the executive government in responding to the pandemic has been the focus of attention and concern. There were two main concerns. The first was whether the emergency public health measures were legal and also effective. Governments have the right and the responsibility to protect the security of national life and the health and well-being of the population. In general, that right is not in dispute. But the key legal issue was the legal basis on which emergency powers were exercised. The second concern was about limiting executive action to legitimate public health objectives and preventing government overreach or abuse of power. Here, the issue was whether the exercise of authority was within the power conferred on the executive by constitution and legislation. When it comes to wide and intrusive executive powers, acting on the homes, workplaces, streets, and personal liberty of the entire population for whatever good cause, history, as we know, is on the side of vigilance and caution. But the dividing line between the good and the bad of executive government can be difficult to draw in the grip of a rapidly developing and novel national health crisis, even in the best of cases. There's been an outpouring of legal scholarship on the subject of executive power. 2 cross-country studies made an early impression on my own work and seem to have had a wide reach in the legal scholarship on executive emergency powers. The first was a worldwide rolling symposium on COVID-19 and states of emergency, co-hosted by the Verfassungsblog and Democracy Reporting International, which took place online from 6 April to 26 May 2020. The symposium brought together a network of international legal scholars who provided daily reports on a range of issues concerning the use of emergency powers in 74 countries. A trend that Joel Grogan, a legal scholar and one of the organizers of the symposium, observed in the data was that while most countries had a constitutional regime for emergency powers, many governments did not in fact declare a state of emergency, but relied instead on ordinary legislation in health and other legislation. In a subsequent journal article, Grogan raised a question that is likely to be a focal point for scholarship and law reform, notwithstanding that a generalizable answer is unlikely. Grogan asked, was it better or worse for constitutional democracy and the rule of law for countries to rely on legislation or states of emergency? The second of the 2 studies was by Professors Ginsburg and Festig from the Chicago and Virginia law schools, which was published in July 2020. This study examined the nature of emergency powers in 100 countries. What the study found was that in general, governments were constrained by legislatures and courts to some degree, not unbound executives, as was feared by many. The authors argued that conventional theories of emergency powers, which were developed in the context of national security crises, did not suit the public health emergency, in which executive governments were more structurally constrained. The point that a public health emergency should be seen on its own terms and not subsumed under general theories of national security emergency seems to me to be the right one. The rub is, of course, determining what constitutes appropriate structural constraints on the executive in a public health emergency in any given context. Let us now look at the impact on fundamental rights. Across the board, severe restrictions were imposed on individual rights. Let us turn our attention now to this side of the scales. On the 24th of March, the 10 human rights treaty bodies issued a joint statement on the protection of human rights in combating the pandemic. These are the 10 expert committees established under corresponding UN human rights treaties, whose function is, broadly speaking, to receive reports from state parties and advise the latter on compliance with international law and to settle disputes with the consent of parties. Among the 10 are the Human Rights Committee, created under the International Covenant on Civil and Political Rights, and the Committee on Economic, Social, and Cultural Rights, established under the treaty with that same name. From the outset, the wider legal and human rights community had 3 main worries. The first was the scale on which human rights were being infringed by the pandemic itself and by government measures, all at one time and in almost every country. Virtually the entire spectrum of human rights protected under the covenant and in national constitutions was put at risk. A second concern was the extent of intrusion into virtually every dimension of ordinary daily life, personal freedom, and social activity. The momentousness of this intrusion was captured in this description of the situation in the UK in a lecture given at Cambridge University in 2020. I quote, "During the COVID-19 pandemic, the British state has exercised coercive powers over its citizens on a scale never previously attempted. It has taken effective legal control enforced by the police over the personal lives of the entire population, decided where they can go, whom they could meet, what they could do, even within their own homes. For 3 months, it placed everybody under a form of house arrest, qualified only by the right to do a limited number of things approved by ministers. All of this has been authorized by ministerial decree with minimal parliamentary involvement. It has been the most significant interference with personal freedom in the history of our country. We have never sought to do such a thing before, even in wartime, and even when faced with health crises far more severe than this one." Close quotes. This descriptive passage, taken from the 2020 Cambridge University Freshfields lecture entitled "Government by Decree, COVID-19 and the Constitution," by a former Justice of the United Kingdom Supreme Court, Lord Sumption, brings home the unprecedented nature of the crisis and its impact on both normal life and constitutional government. The third concern raised by many was that resort to emergency executive powers could give cover to executive overreach, autocracy, and all kinds of abuses of human rights, in particular by the police and the military, who were deployed in many countries to enforce emergency measures, and that those powers might in fact endure beyond the pandemic to become fixtures. Faced with these concerns, the joint statement by the UN treaty bodies to which I alluded, as well as subsequent guidance from the UN Office of the High Commission on Human Rights, the treaty bodies, their regional counterparts, and various other international organizations, sounded a common message. On the one hand, they recognized the need and the right of states to take emergency measures, and even to limit certain rights to protect life and public health. On the other hand, they drew attention to the obligations which states were under to respect and protect human rights, in particular the rights of the most vulnerable in society, among other ways, by ensuring that any limitations imposed on rights were legal, necessary, proportional, and non-discriminatory in accordance with the Syracuse Principles. Let us have a look at how the courts have responded. Of course, the rules that govern the role, powers, and procedures of courts and the judicial process are too country-specific to permit easy comparison of how different courts went about balancing public health measures and the rights limited by those measures. But to get a sense of the different roles courts have played and the complex nature of the balancing act that they have had to perform, we will consider 3 problems that were common for many courts during the pandemic. The first of these was mootness. By that is meant that in many cases, the measure under challenge was repealed or amended before the court could decide the matter, thus removing the harm to the right and rendering the matter moot. Courts decide actual controversies in law. They do not, generally speaking, decide academic questions of law that are not tethered to an actual controversy. But what then becomes of a complainant's right to justice when an ongoing and continually developing crisis renders the case moot? Courts generally have a wide discretion to hear the matter, even if it is moot, but they are careful to do so only in exceptional cases, when to do so is in the interests of justice. For example, when the legal question affects a large number of cases or is ongoing. Many courts, in fact, seem to have taken a lenient approach and permitted cases to continue to decision. In the case of Dolan, for example, the UK Court of Appeal permitted the claim for judicial review of the government's authority to issue regulations to continue on the grounds that whether or not the government had authority under the enabling legislation to make regulations of that type remained a live issue, and new regulations continued to be made under the same enabling power. In South Africa, in the case of British American Tobacco of South Africa, a prohibition on the sale of tobacco and tobacco products which continued in force after restrictions imposed on the sale of other goods deemed to be non-essential had been lifted, was challenged as violating several fundamental rights in the Constitution. A High Court allowed the matter to continue, even though the prohibition had been repealed after proceedings had commenced. The court held that, quote, the possibility of the infringement being repeated under exceptional circumstances of dealing with a new pandemic, coupled with the possibility of the reintroduction of the ban on tobacco, justifies the determination of issues, which, although moot between the parties, raises compelling public interest questions, which require the court to reach a conclusion. A second kind of problem relates to what a court can do when the government's public health response is manifestly inadequate to the situation and human rights are massively at risk, but no case has come before it. Some courts can intervene suo motu, of their own initiative, without a case and controversy coming before it. This was the situation in India during the second wave in March 2021, according to Gautam Bhatia in an article published in Opinio Juris in September 2021. Many Indian states, he writes, many Indian state courts exercised a supervisory jurisdiction, for example, by holding daily hearings to resolve competing hospital claims for oxygen cylinders, which, as many of you may recall, was a major problem in the context of India. The Indian Supreme Court explained the nature of this role in this way. Quote, the jurisdiction exercised in this matter is merely to facilitate a dialogue of relevant stakeholders, the government of India, the states, and this court, in light of the pressing humanitarian crisis. And it is not with a view to usurp the role of the executive and the legislature. This, what the court called bounded deliberative approach, is exercised so that the government of India and the states can justify the rationale behind their policy approach, which must be bound by the human rights framework, which presently implicates the right to life under Article 21 and the right to equality under Article 14 of the Constitution, close quote. The court went on to find that among other problems, quote, there was no national policy on how admission must take place in the various tiers of hospital, notwithstanding the fact that gaining admission to a hospital bed was one of the biggest challenges in the country. And as a result of that, many citizens had suffered immeasurable hardship, close quote. The court directed the central government, quote, to frame a policy in that regard which would be nationally binding, close quote, and went on to specify the parameters of what the policy must deal with. Now, this kind of supervisory injunction would be foreign to many courts. The South African case of Equal Education and Others versus the Minister of Basic Education illustrates a third kind of problem, and this is the one that I will conclude with, which is that the effects of the pandemic and emergency measures often had a disparate impact on the rights of the poor and the most vulnerable in society, such as children. The South African Constitution recognizes a right to basic education and a right to basic nutrition for children. The provision of basic education is a concurrent responsibility of national government and the 9 provinces, equivalent of American state governments. In 1994, the government introduced a highly acclaimed national school nutrition program to ensure that all children received at least one nutritious meal a day while being educated. The program was well targeted to the most food insecure and feeds 9 million children, almost half of all children in the country. During lockdown, however, schools were closed for 12 weeks, and in consequence, the nutrition program was suspended. When schools reopened, the government decided that both the reopening of schools and the resumption of the nutrition program would be phased in. The effect of this phasing in on the nutrition program was that only those returning grades of students would have access to the daily meal, not those who continued learning from home as a result of the government's phasing in policy. This decision was challenged as an infringement of the rights of children to basic education and basic nutrition. The court held that under the Constitution and international law, The state had a duty to respect and protect the entitlement to basic nutrition and education as fulfilled by the nutrition program. That duty included the negative obligation to protect the right. Learners had an entitlement to receive a daily meal, and the phase-in policy diminished that right in breach of the state's obligation to respect, protect, promote, and fulfill the rights in the Bill of Rights. Those students remaining at home would lose their daily meal and continue to suffer hunger as a result of this policy. The policy did not constitute a proportional limitation of that right. Let me conclude with some reflections on possible areas of law and governance reform that are likely to flow from the experience in readiness for a pandemic in future. In the various international reviews that have been undertaken, in particular the UN Secretary General's report, Our Common Agenda, and the review of the international health regulations themselves, one priority stands out above all: the global governance and legal framework that governs international public health emergencies must be strengthened where necessary in preparation and readiness for the next pandemic. In short, we must use the experience of this pandemic to ensure that we are better prepared for whatever may come our way. From the perspective of my own work, reforms in two broad streams of governance seem likely. The first relates to what we might call improving good governance in a public health emergency, based on what we now know. It seems to me that governments face three reform priorities in this area: compliance with the international framework and the role of the national focal areas have been identified as problem areas in the UN reviews. For that reason, the first priority is for governments to review how well their own response to the pandemic was organized and managed. Secondly, they will then have to reform the national governance architecture to bring it into line with the international obligations and the global reforms that are likely to ensue. And thirdly, they will have to assess the effectiveness of the particular health measures that were introduced during the pandemic, drawing on the vast data that is now at their disposal, which allows governments everywhere to assess the efficacy and utility of the measures that were introduced. The second area where I think reform is necessary and likely relates to constitutionalism and the rule of law during a pandemic, the standards and rules that set reasonable limits on government action in a pandemic. Here there are also three priority areas for reform in my view. The first is to review the legal framework governing the authorization, oversight, and termination of public health emergencies, and to bring the national system into line with any reforms to the international health regulations that may ensue. The second concerns a subject I have not had time to discuss, but which loomed large during the pandemic, and that is the use of surveillance technology in public health measures. And it is clear that stronger safeguards for fundamental rights, in particular for data privacy in the processing of health and other sensitive personal data, are needed. The third is to ensure that standards and practical guidance about what constitutes necessary and proportional responses in a public health emergency must be developed and given legal effect for all areas of public conduct that matter. The pandemic is not yet over. Many countries are still grappling with its effects. However, the work of assessing practice and reforming the global health system is already well underway. I feel sure that reform in these two broad areas of pandemic governance and pandemic constitutionalism will occupy many countries for years to come, as national reformers seek to rebalance the constitutional relationship between law and government for more normal times that, it is hoped, lie ahead once the pandemic is over. Thank you.
Great. Thank you so much, Dr. Powell. That was a fantastic and comprehensive presentation there. So we've left a couple of minutes here at the end of today's event for questions from the audience. So please feel free to submit them during the Q&A tool. But going off of what you just spoke about with the need to take a step back and consider what happened, what areas for reform are available to both national governments and on a global stage, do you see a lot of collaboration between different nations and governments on sharing this information, going over lessons learned and collaborating together to improve on some of these reform measures that you've discussed?
Excuse me. Thank you for that question, Michelle. I think one of the extraordinary things about the pandemic is how it unlocked possibilities for collaboration between people within particular professional fields and also across. I remember attending one of the very first seminars on emergency powers held by, I think it was co-hosted by Columbia Law School, Duke Law School, and NYU. And these issues were already surfacing in that discussion. So I think there's been an enormous sharing of information already. But I have no doubt when we stand back and look at this experience, that there is no other historical phenomenon like this one. Never before in history has government and constitutional democracy in particular, everywhere on the planet, simultaneously being tested by the same phenomenon. That's just never happened before. So we have an extraordinary opportunity to turn this terrible experience into knowledge and reform, which can ensure we are better prepared in future. And I feel absolutely certain that that is going to happen.
Great. Thank you for that. I'm also hopeful, and I think everyone here sort of shares your hope in positive collaboration moving forward. So there are a couple of questions that came in, and one of the themes that I'm seeing here is an interest in your view of cultural differences and ways that people might approach this government reform. You sort of spoke to that a little bit in what you just said, but are you seeing blocks of countries? Are there sort of trends in some of this movement that you're seeing in the work that you're doing?
I think there's an enormous amount of common ground. I mean, my colleague and I are about to produce we're about to publish a book on perspectives in sub-Saharan Africa. We've looked at a number of countries there and have some fabulous essays written by younger scholars. And the issues are, at least at the level of governance and law, are by and large the same everywhere. And the sort of issues that are contained in these questions, they may take different forms. There may be different types of institutions involved. But if you read the Kenyan Supreme Court judgments, if you read the judgments in Malawi or the South African court, compare those to the US Supreme Court's judgments on particularly the religious rights, religious freedoms, you're going to see the same sort of issues playing out. This is just an unprecedented governance problem, but it's happened in a context where most of the world's countries are now, in formal terms at least, and very often in positive terms, constitutional democracies. They have constitutions, they have bills of rights, they have elected governments. This is now a norm in many parts of the world. And we can see that particularly in Africa, where there's been an enormous surge of constitution building in the last 2 or 3 decades. So I think that there's a lot of difference between countries, but there's also an architecture of law and governance that is common to many.
Great, thank you for that. So another question that has come in is, relates to some of the public opinion and protests that we've seen globally in response to some of the the restrictions and responses by governments. And in particular, this person is asking about the current case in Ottawa with the trucking protest. But the broader question is, you know, where there are cases of where public opinion about standards and customs on what level of protection is appropriate has veered so far away from the government's response to be addressed at a constitutional level.
I'm sorry, Michelle, what was the question?
So the question is this a case, and this person is referring in particular to Ottawa, the protests there, but I think, you know, the question could be relevant to a number of protests that we've seen globally, where public opinion about standards and customs on what level of protection is appropriate has veered so far away from what the government response is to be addressed at a constitutional level.
Yeah, I mean, I think different countries are handling this in different ways, and with different resources. There's no doubt that that we're in uncharted waters here. There are no easy answers. I think no governments had an inkling about how to manage a pandemic and keep a society going as an organized entity. So these tensions are inevitable in some ways, and social media and technology, digital technology, also helps to create a sense that there is a kind of world crisis out there. But if you look at the numbers, I think, of protests involved across the world, I mean, they're quite small, the numbers. It's small, quite small and vocal, some of these protesting communities. But for me, here's the key issue. This category that we use, often quite glibly in the media, of the unvaccinated, I think this is a category that we need much more thought given to by our senior courts, the constitutional courts and the Supreme Courts. This is a very powerful and very dangerous category. And the reason for me is quite straightforward. When you wrap a group of people in a constitutional category for whatever reason, that wrapping has effect, and it must be justified. For whatever good or bad reason you may have used those categories. And when you're going to apply force to categories that have been identified as a problem in society, we are in very tricky ground here. And we must proceed very cautiously as constitutional lawyers in particular. I think you need to have criteria about what kind of measures are justifiable under the circumstances. For example, it is one thing preventing people from entering public places, so-called vaccine passes and the like. But would we tolerate a situation where the police go into people's homes to vaccinate them forcibly? Of course not. That would be intolerable under the international covenants. But the right to remain unvaccinated is not the right to disrupt social order or to bring a country to its knees. Those are different kinds of considerations. The point that I'm making is that I think we need to think, particularly as constitutional lawyers, very long and very hard about categories. Now, I say this from a personal level too. I come from a country where I grew up in an authoritarian system, where categories that divided and classified people were used and enforced by law. So I have a natural and instinctive concern when we do not look at categorization of people with sufficient criticism in mind and argue for a greater justification. So I would want to see the courts particularly involved in defining what the powers and responsibilities are of all of the parties involved in the vaccination issue.
Great, thank you for that. I guess as a follow-up to that, do you see that being a part of the conversations that are happening? Do you see that being addressed by courts in terms of the categorization?
I think there's an extraordinary amount of responsible leadership that's emerged in this pandemic, actually, wherever you look. I mean, you look at the American courts, for instance. I haven't looked at all of the jurisprudence, but the vibrant legal discussions that have happened between state courts and governments, between state courts and federal courts, has been astonishing. And I think we are better for it in a way, as lawyers, particularly, and as reformers, because it's helped narrow a whole set of important issues that are that no one really had answers to be honest. I mean, who really knew anything about managing a global pandemic on this scale using the tools that we have at our disposal? I think that in some ways courts kind of grew into their role in the pandemic. I don't think it was something that they could just take off the book. But if you look at that case I cited in South Africa, for example, with the school nutrition program, there was a clear example where a court said to the government, you're not going to implement this policy. It has a disparate impact on 9 million children. You yourself put this policy in place in order to tackle issues of equality and deprivation. Whatever you do, you go and implement this policy. And in fact, the court went further. It placed, similar to the Indian court, it placed the government under a supervisory injunction, and it required it to report to it and so on these programs. Now, let me close with this final point on this issue, though, is that courts are very different. So it's hard to compare a South African court, for instance, and an Indian court with, say, a US federal court, where you require, in US court systems, you require, generally speaking, a case and controversy between people, between parties, before courts are involved. So courts don't have a suo moto jurisdiction where they can intervene of their own accord, as they do in India. Not in South Africa, but there are parallels, if you like.
Great, thank you for that. I wish we had another half an hour. We've gotten some other questions, but I want to be mindful and respectful of your time and those of our attendees. So thank you again for taking the time. It is evening in South Africa, so thank you for taking time this evening to speak with our audiences. Thank you to those of you who are able to tune in. Our next talk will take place on March 1st at 12:30 p.m. Eastern Time. The topic is security in perilous times, in search of a new paradigm. So we hope that you will join us then. And again, a big thank you to Dr. Powell for today's presentation. So thank you all very much and have a wonderful rest of your days.
Thank you very much.
Thank you.